been following social media, you notice that a lot of Nigerians have been outraged in the Ochanya case. This is a case involving the young girl who died at the age of 13 after being raped by her cousin and his father. It's such a sad case. In 2022, a court in Benue State, Nigeria, presided over by Judge Itoyiman, cleared Andrew Ogbuja of the charges, citing conflicting medical reports and an inability to match his DNA to the evidence. As for his son, Victor, he was never tried because he suddenly disappeared just before the case was about to be prosecuted. This is such a harrowing and sad case, this story, and my sympathies go out to the family who, after 7 years, still haven't had any justice. But I want to point out two critical factors in the case. Number one, there were two conflicting medical reports, and number two, an inability to match the father's DNA to the crime. Now, it's very easy to say the justice system has failed the family in this case, but the judge looked at the facts that were presented to him at the time. According to the judge, one medical report stated that the young girl died of natural causes, while the second report from the police forensic laboratory stated that she died as a result of a disease related to the sexual abuse. So, the question I want to ask is, why can't Nigeria get these basic issues right? Why can't the relevant agencies apply DNA testing, DNA sampling, DNA profiling correctly? Why? In this day and age of technology, with the technology boom, why are there conflicting medical reports still? Why can't we have a professional autopsy report? Why would a suspect disappear without trace and the police don't have the right intel to find him? These issues are actually the problem. They are deep-rooted issues that really require being addressed.
Rape is a criminal case, it's felony under, the laws of Nigeria. I think section 256. But the problem is how you provide the evidence. The Edward Ogbuja, I think that's the Andrew Ogbuja. He was able to escape because they said the case could not be proven beyond reasonable doubt. For more than 20 years, civil society groups have been arguing that that section of the Evidence Act has to be reviewed because the Evidence Act in Nigeria, with regard to rape, talks about proof. Yes. And the proof is so embarrassing. They will have to say you come and prove penetration, that the person escaped into the internal anatomy of the female Homo sapien beyond the labia majora. Who is going to prove that? How are you going to prove that?
Many cases in Nigeria are often not handled properly due to lack of evidence. How evidence is handled from the point of arrest through to the trial is very critical. It highlights the need for proper evidence gathering, protection, and use of DNA profiling in serious crimes like murder, sexual assault. Also, tampering with evidence should have strict legal consequences in Nigeria, and all agencies involved need training to ensure proper handling, including autopsy reporting. Many civilized countries have managed to sort out these issues. Why can't Nigeria do the same? Without fixing these systemic issues, access to justice will remain limited, as we can all see in the Ochanya case, allowing guilty individuals to go free. What do you think? What are your thoughts on this? Let us know in the comment section. If you like our content, like, share, and subscribe. Till next time, take care of yourself and each other.